So let's go ahead and kick it off. Why should you even care about contracts at all? Well, for number one, they're unavoidable. If you're going to be running a business, you are going to be signing contracts. Contracts are just something the business owners are going to have to deal with. And there are so many different kinds of contracts that you are going to experience as a business owner. They're just unavoidable. So you have to know something about them, right? It's like if you were playing football, not knowing what a football is, it would be a problem for you, right? Because you can't play football without the actual football. You can't run a business or engage in business of any kind without dealing with contracts. So it's just part and parcel of what it is that you're going to be doing. They also contain what I would like to refer to as the rules of the game, right? You can't be, it can't expect to be very good at a game or even win the game if you don't know the rules of the game, right? Let me put it differently. If you're a gambling type, do you look at your cards before you bet on your hand? Those analogies are very apt when it comes to contracts, right? They contain the rules of the game. They contain all the information that you need to know before you make a bet on your business along the way. It would be foolish to think that you're going to be successful in a game if you don't know the rules in advance and how to play by the rules and how to make sure that the rules are in your advantage. Contracts in their very basic way are guidelines for making better, more informed business decisions. And as we go through the contract checklist, right, think about it as sort of a checklist of things that you might need to be thinking about when it comes to any type of a business venture or business relationship. They really are guidelines for making good business decisions and being well informed, going into some type of an engagement with your eyes wide open and making informed decisions. And for no other reason, your personal risks, your personal assets are often at risk whenever you're operating a business. We talked about that in our last session about personal guarantees. So you really need to understand what a contract says because oftentimes those contracts are going to place your personal assets directly at risk relating to your business. So protect yourself, protect your own assets, protect your family by making sure that you have some working knowledge about the ABCs of business contracts. So there are so many different types of contracts that business owners are going to experience. An operating agreement, if you have a limited liability company, or maybe bylaws for a corporation. You might work with consulting agreements. Many business owners are asked at some point to sign a personal guarantee, guaranteeing pledging their personal assets to guarantee obligations of their business. Perhaps you have a shareholder or a partnership agreement. You might sign a lease for your office or your warehouse. You might also sign a lease to rent equipment or rent a vehicle of some kind. Loan agreements. All businesses typically have a loan at some point along the way, and those are definitely agreements that you're going to have to sign. Um, every business has vendors, right? Businesses that you buy materials from, you buy services from, those all involve some type of an agreement that you're going to be signing. Employment agreements. Some businesses use employment agreements and franchise agreements. If you are operating a franchise of some kind, you're going to sign those agreements as well. They're kind of hard to miss. They're usually about 100 pages or long, and there are many different aspects to them. So lots and lots of different types of contracts that are out there that business owners, and those are just a few of the ones that we see very frequently. So let's talk about some contract myths that I hear from time to time. Here's one: just trust me, right? You don't need a contract. Just trust me. We just have a good relationship, maybe a handshake kind of a deal. Um, you know, that's just not true. You can have a verbal contract, right? Just a oral agreement. They are enforceable, right? They can give rights to either party, but the problem is the terms are basically not set in stone. So you have your version of the truth, and whoever's on the other side of that arrangement has their version of the truth, and it's ultimately a problem. You know, each of you are going to have your own different perspective on exactly what the terms of that agreement are and what they mean. And it's usually not a good idea to enter into a business arrangement with a just trust me kind of a basis for that arrangement. But I see it again all the time, and not just with neophytes and new business owners, happens all the time. Here's another one. We don't need a contract, right? I've seen this actually happen. Experienced business owners, right? Have been in business for many years. They have thriving businesses and they feel like they don't need to have something in writing between the two of them. That's almost always a recipe for disaster. And it really is a kind of a red flag. If somebody says we don't need a contract, that usually means that they're probably planning to screw you at some point along the way, or they want to play in the ambiguities to their advantage. So that's always a red flag. Here's another one. It's a standard form, or another variation of this is this contract just has the standard terms. I'm just going to say that there really are not a lot of quote unquote standard forms. And what's standard mean, right? Is it standard for them or is it standard for you? Because those could be two completely different sets of provisions, right? So don't accept that there's some standard that you have to agree to along the way. And we're going to talk about that a little bit later. So this is a fallacy. It's a myth that there are standard terms that are always used in every situation, and therefore you should just accept them. That's just simply not true in the vast majority of instances. Here's another one. This is a biggie. I have a contract, so I'm good. Um, it's a fallacy to believe that because you have a signed contract, that your rights are completely protected. So much of what dictates what happens in a business relationship is about what's outside the four corners of that contract. Here's an example. Somebody that filed bankruptcy last week, you could give them a loan and they'd give you back a promissory note that says, I promise to pay. How good or how enforceable do you think that promissory note is going to be if they miss their first payment that's come back to you? Not very good at all, right? You wouldn't expect somebody that has filed bankruptcy to be able to honor a contract. And that's an example of what I'm talking about, right? Maybe you didn't know that they filed bankruptcy last week, but that's part of what due diligence is all about. Finding out a little bit about what this other person is all about, what their credit history is, so that you know what other types of things that you need to do in order to protect yourself if you're going to enter into a contract with that person, right? There are lots of things that are outside the four corners that can have an impact on the quality and enforceability of the terms of whatever agreement is that you have with somebody. So it's a fallacy. People have a false sense of security thinking I've got this signed agreement, everything is okay, or I'm fully protected. That is really just not the case in many, many instances. So where do contracts that business owners come from? They come from a lot of different sources. One is, sort of the free document internet search. That's really like playing roulette, so to speak. You can go out there. There are free documents available online. You might find versions of contracts that have been used out there. There are lots of different free documents out there online. And all I'll say is, this, your life lesson is you get what you pay for. So, if it's free, it might have some value, but how do you know whether it fits what your needs are there, or what's missing from it, or how it's been tailored by whomever worked on that contract, which way it's tilted, so to speak. So free really means it's there, but it may not necessarily be a good fit for whatever it is that you are trying to accomplish. There are government produced contracts that are out there. The IRS produces documents. The Corporations Bureau, in whatever state it is that you're in, produces documents that are contractual in nature. So governmental entities may produce contracts. If you're entering into a contract with the government to provide services to the government, they are going to produce contracts that you are going to be required to sign in some way, shape, or form. So the government produces contracts that sometimes your business is going to be involved in. You may purchase forms online, right? And there are a lot of resources that are available out there for purchased contracts. When you pay for something. A couple of examples are the PA Association of Realtors sells what they refer to as a standard agreement of sale for both residential and commercial real estate. And these are widely used for real estate transactions in Pennsylvania. And you can buy that contract. And it's a very fulsome contract. You need to understand it from whichever perspective that you're coming from, because there might be changes that we would suggest that you'd want to make, but it's a pretty fulsome contract that is specifically tailored for real estate transaction and anticipates a lot of the issues that can come up in a real estate transaction. So these purchase documents are definitely better than the freebies that you might get out there. Another set of contracts um, for contracting for construction jobs or architectural jobs are produced by the American Institute of Architects. You may have seen these out there if you're a contractor. There are a variety of forms of them, short forms, long forms, different types of projects that are out there, subcontractor agreements. These are also very fulsome contracts that are specifically tailored for construction projects involving real estate and tailored to whatever your relationship is to the project. So there are lots of contracts that you can purchase online, and some of them are very good. You might have a subscription service, like the Society for Human Resources Management. If you subscribe to that as a business, they are specifically all HR, human relations type, employment type documents. They have a wide variety of documents that you can download and use for your business as a result of your subscription there. And many of them are very good documents. I'm not saying that they're um, cut and paste and don't need to be edited, but they are very good documents that are great starting points for whatever it is that you are using them for your business. Um, Now, there are other people's contracts. Probably most of the contracts that businesses use are what I would refer to as other people's contracts, meaning a contract that is sent to you by the other side of the transaction. Vendor contracts, leases are examples of these where they are sent to you and then you are being asked to sign them. So these are the other side's terms. They're other side's standard terms that they're sending to you, asking you to consider and potentially sign. But I think the majority of the contracts that you'll see as a business owner are what I refer to as other people's contracts. And then finally, your own contracts, and especially contracts that you've had prepared by an attorney of your choosing that are specifically tailored for whatever your needs are. And it might be a standardized contract. Let's say that you have a business of doing home improvement and you've had an attorney prepare a home improvement contract that you use repetitively with your residential customers. Maybe you have one that's slightly different for your commercial customers along the way, but you know exactly what's in there and you're pushing it out to your customers, asking them to sign it so that you know exactly what the terms of your relationship are going to be with your customers each and every time. There's a lot of benefit to that kind of a thing. Or maybe this is a particular transaction where you're buying a business or you're selling the business and you've had engaged an attorney to assist in negotiating and then preparing that contract for you. But a whole host of those contracts can come from an attorney that you have retained for whatever the transaction is. So let's switch some gears and go into what I would refer to as a contract review checklist. And this checklist isn't going to be applicable to all contracts, but it's going to be applicable to the vast majority of contracts that you see out there because there are certain elements that should be in every contract. There are some basics that really should be in there. So this checklist can serve as a checklist to say, these are the things that should be in the contract. If they aren't in there, that is a very basic red flag for you that something is missing. That can be one of the hardest things to realize is somebody presents you with a contract and your initial paradigm might be that this contract contains everything that it should, that there's nothing missing from it, right? There are no issues, topics, whatever missing from this contract, but that's not always the case. So it's always a good idea to have a list of topics that should be addressed in the contract and compare whatever it is that you have to that list to make sure that there's at least addressing all of the very basics that are necessary for a decent working contract that's going to help you figure out what the terms of your relationship are with the other side. So the first part of our contract review checklist begins with the parties, right? Who are the parties to whom this contract applies? Right, very basic. This contract is between Joe Blow and Jane Smith, right? You got to identify who those parties are in the contract. I can't tell you how many times I've seen one sent and that's blank, in the contract, or it's wrong in the contract straight up. Are the full names of the parties identified? It's not unusual to see a contract that has a partial business name, but it doesn't have the complete business name, or maybe it's just their trade name and it isn't the actual business name. Okay. But it's really important to have the parties identified specifically in the contract, because if something goes wrong and you need to file suit at some point along the way, that contract identifies who is obligated, right? And if you can't figure that out, you're going to have a pretty tough time figuring out whose name to put on that lawsuit in order to sue along the way. Is the description of the parties too broad? So sometimes you might see a contract that says this is between, just say, for example, Verizon and its parents, affiliates, and assignees. Well, that's a very broad description of who the parties are. And sometimes companies want to do that because there are other provisions in the agreement that they want applied to all of their various and sundry companies. Very prophylactic thing to do. Well, you may not want to be obligated to all of those other companies. So you got to pay attention to who gets the benefits of this agreement. And do you want to be obligated to all of those different companies? It's a very basic question that you need to answer along the way. Okay, next, purpose of the contract. So my personal preference, I don't know that this is absolutely 100% necessary, but pretty much I think it is the purpose of this contract stated very basically. So for an introductory paragraph, like a preamble, so to speak, why are the two of you signing the contract? What is the purpose of this contract, right? Maybe it's these parties are going to engage, the company A is the manufacturer, company B is being engaged as a sales representative, and the purpose of this contract is for the manufacturer to supply goods that this salesperson is going to sell, right? Maybe it's just very basic like that, but it really should be stated at the beginning of the agreement. Sometimes it's not so obvious whenever you look at it. Is it described sufficiently along the way? So I think it's always good to sort of tee that up because it provides the context for reading the balance of the contract so you better understand exactly what's going on there. Next are the obligations. This is sort of the meat and potatoes of the agreement. So does the contract describe the obligations of the respective parties, right? This is very basic. What is party A supposed to do? In our example, the manufacturer is going to supply goods, supply them in a timely fashion, supply them without defects, those types of things, right? And the other side, the seller, is going to sell their products, perhaps sell them at a minimum quota, sell them at rates that are approved by the manufacturer. There are lots of different things that would go into the obligations. It really depends on exactly what the nature of the agreement is, right? Maybe it's a construction contract where you've got an owner and you've got a contractor, and the owner wants a pool to be built at their property, and the contractor agrees to build a pool on this particular property. And maybe it's described in some type of way, exactly what it's going to be, when it's going to be provided, and so on and so forth. So they really need to have that on there. Very importantly is, does it describe the limits on the scope of the party's obligation? So, um, exactly what is it going to be? If it's a sales agreement, um, does the scope of the agreement cover only a certain geographic area? Does it cover only a certain class of customers? Perhaps it only covers certain products or services, along the way. So describing the scope of the party's obligations is also very important, because you don't want to have your obligations defined later for you in the event of a dispute. You would rather know exactly what it is that you are obligated to do under this agreement, so that there's no misunderstanding and no disagreement later on to say, well, I thought you were going to do this. And you say, no, I only agreed to do, this other thing along the way. It's very easy to have a misunderstanding about that, but it's very important, and that can all be avoided if you very specifically describe the obligations, in the agreement. If the contract is for the sale of something, like you're selling assets, or you're selling the assets of a business, does it sufficiently describe the assets to be sold? Because sometimes, whenever you're selling a business, you don't want to sell all of the assets, right? Or you have a business that has a variety of lines. Let's say that you've got a restaurant and you operate food trucks that are logoed to your restaurant. If you're selling just your food truck business, you'd want to make sure that you describe that you're only selling the food trucks and the assets associated with the food trucks, but you're not selling the rest of the restaurant business. That's just by way of example, right? Um, then also, it's very important to exclude certain assets from the business. So I had a guy that had a crane company. I helped him sell his business, and he forgot to include in the assets that were excluded from the sale his pickup truck, right, which was titled to the business. And the sales agreement, of course, said that he was selling the crane business and all of the vehicles associated with the crane business. He forgot that his own personal pickup truck was titled to the business. And that was a problem, because it was a contentious transaction at the end of the day. And after the fact, we had to go to the buyer and say, oopsie, we forgot to exempt his pickup truck. Can he exempt that after the fact? We were able to get it all done, but that's just an example of how things can sort of go wrong if you aren't particular about what you are exempting from whatever the scope of the transaction is. So consideration or payment, right? What's the exchange? What's the quid pro quo, right? As that term is often used. What is the exchange of value in between the parties? It's often going to be money, right? So are the payment rates stated clearly? Does it include an assumption of liability on the other side? So for example, an agreement between two parties to sell a piece of real estate might also say this real estate has a mortgage on it that has a balance of $100,000. So I am buying the property is worth $300,000. So I'm going to pay you 200 in cash, and I'm going to assume your liability for the balance of the mortgage, which is 100. That adds up to the sales price. So that can be part of the consideration that is exchanged. So it's not always just money. It might also be an assumption of an obligation of the other party. Notice, um, you know, it's not unusual at all for business people that are in business or have a contractual relationship to have to communicate about a variety of things during the course of their association with one another. Of course, invoices are one way of communicating between parties, right? You owe me this amount of money because I provided these services. They might need to exchange communications about, deadlines. If you're a contractor, you're going to say, I have completed all of the work that entitles me to progress payment number one. That's sort of invoicing, but it's also a communication that I have completed certain types of things. Or maybe towards the end of the job, the contractor says, I believe that this project has reached quote unquote substantial completion, which triggers the owner's ability to inspect the work and produce a punch list. And there are lots of timing things that have to happen as a result of that. Maybe it is a communication that something has been delivered along the way, or changes to the relationship of one kind or another. So it's really important for the contract between the two parties to say, this is how we're going to communicate with one another in an official way so that um, we know exactly what to expect in the way of communication, right? you know, does the contract contain an address for notice purposes? So is notice going to be sent to a particular mailing address? If so, what's that mailing address? Because it's not unusual for businesses to have multiple locations. You need to know exactly where it is that you're going to be sending the notice. Is the notice going to only be in writing, or can it be via email or maybe even text message? I mean, there are so many different ways to communicate these days. It's important for the contract to specify exactly the manner in which notice is going to happen. So very important. I mean, there's a lot of, if you're in a real estate transaction, and this has happened, of course, where the contract says that there is a period of inspection, like say 30 days after the contract is signed, and there's a down payment that's made, and the contract says that the buyer can cancel the contract for any reason or no reason at all and get their deposit back prior to the expiration of the 30-day notice period, right? And so let's say you're on day 29 and you're the buyer and you now have cold feet because of something that you discovered, at the property that says, I don't think I want to buy this place anymore. So now you've got a very short period of time to tell the other side, exercise your right to bail out of the deal. So if the contract doesn't say exactly how it is that you're supposed to notify the seller that you want to bail out of the deal, and you just send it whenever, the seller could say, I never got it because you sent it to the wrong address and I didn't receive it in time. Or you sent it via email and I didn't get the email, or that's not an email address that I use anymore, or whatever it is. Invites all of those ambiguities and potential problems along the way that you absolutely don't need to have. So it's very important to have those notice provisions in there. Payment terms. Super important to address these very thoroughly, right? Number one, is there a start date or is the start date for payments stated, right? When are payments due, and what is the first day that a payment is due? Very important to understand that. And then what's the frequency of payments under the contract, thereafter? So if you're a vendor and you're providing services to a customer, you're going to want to say that my invoice is being sent and payment terms are net 10, net 30, whatever it is, but you have this amount of time to pay me after I send you an invoice. What's the method of requesting payment? Invoice. What should that invoice contain? Because there are so many fights over invoices that lead to non-payment, that lead to other problems, along the way, because the parties didn't have some type of a meeting of the minds in advance about exactly what information was going to be put in that invoice. And some businesses, when they're not down on their details, don't produce very good invoices that are very descriptive. And the customer who has to pay wants to see more detail in that invoice. So it can be a real source of consternation between two parties that can be a problem. So, it makes sense to talk about exactly the method of requesting and what's actually going to be, in that invoice. What's the method of submitting payment requests, stated? Do you mail them? Do you email them? Is there some type of a website that you have to upload them to? What is it? But you don't want to skip over that detail because it can get in the way of you getting paid if you're the vendor that is providing the work and entitled to get a payment. And does the contract address what happens when payments are late? I see that skipped over very frequently. Businesses, their customer doesn't pay them. Um, their customer's not responding to them for requests for payment. They call me and they want to now file suit against their customer, and they want to know if they can get their costs and attorney's fees paid um, in addition to the amounts stated. And the law doesn't really provide for that. In most instances, it's really going to depend on what the contract says. And if your contract does not address what happens in the event of late payments and what other remedies are available, then you're going to be kind of stuck because your contract is insufficient in that regard. Term. What is the term of the contract? This is very important. What's the effective date? So when does it begin? When do the obligations of each party begin? Believe it or not, sometimes that can be pretty vague. Case in point, you have a lease that a business has signed, and the landlord has agreed to make certain improvements to the property in order before the tenant moves in, right? Um, so it sort of invites the question, when are the improvements completed such that the tenant's responsibility to make payments now commences, right? And usually that period of time between signing the lease and having the improvements done, that isn't counted for purposes of the term of the lease. So this can get very fuzzy if the agreement is not specific about these kind of things, and again can lead to a lot of disputes unnecessarily, right? Is the length of the term stated? Also very important to understand, how long do these parties have an obligation to one another? That could be very important if it is in a relationship that isn't working out so well for you. You may want to get out of it as soon as you possibly can. So you might want to find out exactly, you want to know exactly what that term is. Are there conditions precedent that must be satisfied before the term begins? That's a very good example of tenant or land improvements to the property before a tenant, moves in along the way. That's a good example of that. Does the contract address the parties' respective rights to cancel or end the term prior to the conclusion of the term? That can be very important. There might be only in the event of a breach where somebody doesn't perform. Maybe it's in the event of a breach, but only after notice and the right to cure whatever the breach is. Sometimes the agreement would allow the party to cancel it at any time with no notice or maybe some advance notice. So those are important things to understand. If you're going to be making an investment and making a commitment in hopes of having a longer term relationship with this customer to recoup your initial investment, then you're going to want to pay attention to the provisions in the contract that discuss term, because if the other side gives themselves the ability to cancel the contract on 10 days notice or 30 days notice, then it's possible that you could have made that upfront investment that you could only recoup if the term is, let's say, a year, and the other side all of a sudden makes a decision to terminate the contract 60 days in. And now all of a sudden you've lost money because you didn't pay attention to the provisions in the agreement that gives them an early out. Does the contract state whether the term can be renewed? Very important. Sometimes, there can be a renewal provision that says it can be renewed. Typically, it can be renewed by one side saying they're exercising their right to renew it, but they might have to give notice in advance of the end of the term. So again, it's important to understand exactly when the end of the term of the relate contract is, and also pay attention to how much time in advance you have to exercise that right to extend the term. Otherwise, you might lose the ability to do that. It might have what's called an evergreen provision that says it automatically renews unless you opt out of the renewal. And it's important to make sure that you've got your deadlines on the calendar so that you know in advance. You give yourself a heads up, maybe 30 days prior to that deadline, to make a decision. Do you want to renew or do you want to opt out, kind of a thing? But if you're not paying attention to the deadlines, if you haven't read the contract and know those provisions are in there, then you can miss out on very important rights to your business, and you might find yourself having to move or renegotiate the contract at worse terms. Or maybe you're stuck in a contract that you don't want to be in anymore and you would like to get out of it. So I've seen lots of problems related to that, over the years. Time for performance, also very important. Important. Does the contract state the completion or the closing date of whatever it is that you're supposed to do? This is very important in construction contracts. Are there sub deadlines within the time of performance? So inspections, due diligence, project milestones along the way. A contract can have a variety of deadlines within the context of the arc of the entire timeline of the agreement, and all of those can be very important along the way for the rights of the parties. So it's very important to understand what the timing mechanisms are within the contract and be paying attention to those. Does the contract state specific items that have to be delivered by the completion date or the closing date or somewhere in between? These are all very important things. And, this gets to like expectations, right? So, if you're let's say the owner, if you're the one that's receiving the delivery, you're going to want to think a little bit about when you need to have these things and what your expectations are going to be. That really requires you to sit down and have some thought beforehand, right, of what it is that you want. And, that seems basic, seems like common sense, but it really isn't, right? So think about it this way. It's kind of the difference between I need a copier, right? Or I need some type of software for my company, right? And it's the difference between you've identified a need, right? And it is very basic level. There are two different ways to go from there. You can either sit down and think about what exactly it is that you want, whatever that product or service is that your business needs, and write down basically a list of expectations or specifications. And then you go to market with those. That's what is commonly referred to as a request for proposals, where you tell the vendor specifically what it is that you're looking for, what you want, and they have to then make a proposal to you, and you get to see how well they match your lists of wants and desires, right? As opposed to saying, I need a copier, and then you just call three copier salespeople and they send you proposals. Well, are those going to do what you want them to do? Are they going to meet the needs of your business? If you haven't thought about those in advance, then you're really kind of in a bad spot to determine or evaluate whatever these proposals are for your business. So, when you think about the time of performance in a contract, it really does force you, as the recipient of whatever the product or service is, to think about what it is, what you want, how you want it, when you want it, and those types of things. It's a very good thought process to go through. That's why contracts kind of force you into what will hopefully be some good decision making and good thinking about the basics. Representations and warranties. These are promises that each party is making to one another that serve as the basis for the agreement, right? You have represented to me that you are a contractor that has experience building swimming pools. And on that basis, I am agreeing, I'm signing this agreement. If it turns out that this is the first pool that you've ever built, then our agreement is based on a false premise, and it gives it gives me the right to perhaps cancel the contract if I find out that you have absolutely no experience whatsoever. That's an example of what a representation and a warranty is. They can be, like many things in contracts, they can be mutual or they can be unilateral, right? They can also be different than one another. But these are promises that both parties are making to one another that serve as the basis for even entering into the agreement. I represent to you that I have the ability to pay the loan that I am taking from you. If I've lied about that, then that can serve as the basis for breach of the agreement or even a claim for fraud of some kind. Covenants are also promises that the parties have made to one another as well, that they promise to do certain things within the context of the agreement. Sometimes these covenants extend beyond the termination of the contract. So you might agree to um, cover the other side's costs in the event that they sustain losses or damages as a result of the work that you've done for them, kind of a thing. That's a covenant that could extend beyond the termination of the agreement. These are really important to pay attention to because they can really extend and broaden the obligations that you have under the agreement. Conditions. Also, these are conditions that have to be fulfilled in order before you have to do what you say that you're going to do in the in the agreement. Um, so they can also be mutual or unilateral. I promise to produce this, and that's a condition precedent to your obligation to pay me. So I promise to deliver, um, and if I don't deliver, you don't have to pay, kind of a thing. That's an example of conditions that have to be satisfied prior to the closing or the completion of the contract. This is very common in a purchase agreement of some kind, especially for real estate. So if you're buying a piece of commercial property, a condition that the seller promises to fulfill is that the property will be free of liens and encumbrances and conflicting rights from other parties. So I promise that the title to this property is going to be clean, so to speak. And if I can't deliver that, that's a condition that if I can't deliver on, then you don't have an obligation to close on the deal. You don't have an obligation to pay me if I can't produce that, right? If I can't give you this property in good condition, you don't have to pay. That's an example of a condition. And that can take a variety of forms depending on what the type of a contract it is. So termination, I'll have to speed up here just a little bit. It's really important to understand when parties can terminate the contract. Do they each of them have the right to terminate it, or can only one party terminate it? And whenever you see unilateral rights where there's no mutuality, that usually means that that contract is a little bit unfair to somebody, along the way. Can the contract be terminated without cause, right? Terminate for any reason or no reason at all. Sometimes it can only be terminated if the other party has breached or if certain things, arise. So it's not unusual in an employment contract to say, this employee can be terminated for cause, or they can be terminated because they've been convicted of a crime, or something like that, that has nothing to do with their work, but they can still be terminated because that's a type of a situation where the employer isn't going to want to be associated with them anymore. And does the contract state specifically the grounds for termination? Also very important. So again, it forces you to think about what your expectations are, in going into that arrangement and saying that if these things aren't met, then I want to be able to get out of the deal. And you can put that into the agreement and tell them in advance so that they know what they have to deliver, and you know that you can get out of the deal if they don't deliver on that, just so that everybody has a good understanding of one another. It's very important to communicate those things. Um, it's also important to know whether if you terminate, do you have to give notice in advance? Does the other side have the right to fix a default? So let's say that the contract gives you the right to terminate if you're not paid on time. Well, the contract might say that You have to give the other side notice and give them 10 more days to make payment. And if they pay within that 10 days, then your termination right goes away. So that's an example of how that might work. Default, very important. What does default mean? So it can't be any little ticky-tack thing that happens, in the contract. So the other side is supposed to deliver a product to you and they deliver it and drop it off on your front porch and they don't actually bring it into the house. And your expectation is that they're going to bring it into the house. And you want to terminate the agreement because they dropped it off on the front porch. That's probably not a default that is going to get you out of the agreement. So it's important to define exactly what default means, because there are, ticky-tack things, or if you're Catholic, like the venial sins and then the mortal sins, right? The mortal sins are the substantial default, the material default, as it's referred to, that say, if these things happen, then I get to terminate the agreement, or it gives me some type of remedy, against you. Does the contract say address defaults only of one party? Right? If it is, that's a red flag that this is not fair. If the other side's default is not addressed at all, then you should really insist that those provisions be in the agreement to protect yourself, right? Are they adequately described? Are there different classes of default, payment default, non-payment of default? Because those might mean different things. You might feel more strongly about one than you do the other. So all of those things are important to address. Dispute resolution, very important also. Does the contract say how disputes are going to be resolved? In the absence of any type of language to this effect, the parties can always sue one another in court. That's always available to them under the law. But you can agree to a specific mechanism of how disputes are going to be resolved. For example, the contract can say we agree to engage in some type of negotiation prior to filing a lawsuit, right? We agree to have some type of a meeting to talk about whatever it is that we disagree about and try to get it worked out. It might also require parties to engage in more formal mediation with a mediator that they pay, or even arbitration, where they pay an arbitrator and go through, make the American Arbitration Association or some other form of arbitration that keeps them completely out of the court system entirely. There might be lots of reasons why you'd want to do that. It can also specify what law applies to the case and where lawsuits are going to be filed in the event a lawsuit is filed. It can say the state, it can even say the county where all of that litigation must occur. Very important for you to pay attention to, because if you're in Pennsylvania and the other side's in Texas and the contract says that all lawsuits arising out of defaults have to be filed in Beaumont County, Texas, that's a faraway jurisdiction. It's also very remote, and it would be very expensive for you to hire somebody and sue them there, and very inconvenient for you. So you might want to take that into consideration when uh, discussing that. Perhaps you'd want to push back and say, hey, how about we do arbitration, right? And it can be governed by Texas law, but we don't have to go down there and do it. It can be a virtual arbitration, and that makes things a lot more easy for you. What are the remedies? We've sort of touched upon this before, right? In the event somebody defaults, what happens? Do you get to terminate? Do you get to sue them for specific performance to get the benefit of your bargain? Maybe you get to sue them for damages. Do you get interest? Do you get penalties? Do you get costs? Do you get attorney's fees? What are you entitled to along the way? Maybe there is just some type of a liquidated damage clause, which is common in real estate transactions where, if the buyer defaults, the seller gets to keep their hand money and that's it. There's no lawsuit. They just get to keep their hand money, and they both agree that that's adequate consideration for the buyer backing out of the deal. You can agree to that type of a thing too. And is there a time limitation on exercising these remedies? Because it might say, 1 year after the deal is over, you have 1 year to file suit, and if you don't, then that's it. Your rights go away. You can also limit that as well. Um, Confession of judgment clauses. These are something that you'll see in commercial agreements. These allow um, the non-defaulting party to basically not go through the whole lawsuit process, but rather just enter a judgment against you for whatever the amount is that they believe that is owed. And, that counts as a regular judgment. And it's very difficult for you as on the business end of a confession of judgment to defend those and open those and litigate those and assert your rights. So if you see that type of a provision in an agreement, be very, very careful about agreeing to that kind of a thing. And you may want to put limitations on their abilities, put some roadblocks in front of them that will slow that process down before they get to entering into a default judgment. And you might, or a confess judgment, you might want to protect yourself as well. So very important to take a look at. I'm sorry, I'm getting so close on time. I'm going to skip back to the do's and the don'ts here. And all of this stuff will be available um, in the replay of this webinar. One final thing on these contract checklists. I often see contracts that refer to exhibits that are attached to the agreement or supposed to be attached to the agreement, and they're not. So if it refers to exhibits, those are part of the contract. 9 times out of 10, those are part of the contract. And so you'll want them to be attached. They can't be blank. You want them to be attached. And you want to make sure that whatever the terms are in the exhibits are not inconsistent with the terms in the main contract itself. That very easily can happen, and I see it all the time. And that can really make understanding exactly what the obligations are very different. Okay, some key takeaways, some contract dues. Number one, do have a list of your expectations ready before negotiating the contract. Hopefully you can see through all this checklist that, all these checklist items really make you go through a process to think a lot about what it is that you want out of this deal. And you have a good list of expectations in advance so that you know what you want and you can make sure that the agreement includes the things that are most important to you. Of course, do read the contract. It's surprising how many business owners do not actually read their contracts. After you've signed an agreement, do set reminders for important deadlines. Put them on your calendar. Delay delivering email to yourself in advance of a deadline. Don't miss the deadlines. It's a very common mistake that even seasoned business owners make, that they don't pay attention to those. Do ask for and save a fully signed copy of the contract. This is super common that business owners do not keep fully executed copies of these agreements. That can make enforceability a real problem. And do use a qualified attorney to review, draft, and help you negotiate contracts that are important to your business. There are lots of ways to retain counsel to review your contracts that are very cost efficient for you. And then finally, be willing to walk away. Um, you have to be willing to walk away from the agreement if you possibly can. That's ultimately your best negotiating chip, is that you just don't enter into a bad deal. Some don'ts, don't make assumptions, right? Don't assume something is or is not in that contract. Make sure that you read the contract and understand exactly what's in there. Don't sign something that you don't understand. There's a lot of legalese and gobbledygook in contracts. It's very difficult to understand, limitations on liability and indemnification, and all those types of provisions in these contracts that can be very thick and very difficult to understand. Don't sign something if you don't understand it. Contact an attorney. They can help you understand exactly what's going on in that contract. Don't proceed as if everything is non-negotiable. I would just not believe that. I encourage parties to attempt to negotiate contracts, because if you ask for changes and the other side says, no way, Jose, at all, then that's a pretty good indicator of how that other side is going to be to deal with in the event something goes wrong in your relationship. They're probably going to give you no quarter. Maybe that says to you, I don't know that I want to be in this relationship. This isn't really a two-way street, so to speak. So, always proceed as if things are non-negotiable, but you have to be prepared to explain why you want the changes made along the way. And you'll find, I think, that in many instances, there's at least some willingness to negotiate. Don't skip over the boilerplate, right? You have to know what's in the agreements. There are very, very important rights in that boilerplate that are going to impact you. If everything goes swimmingly, then you probably don't have to worry about them. But you know what? The way life is, it isn't going to go swimmingly every time. And one of this boilerplate could have a material impact on you as a business owner. And so it's important to know that. And don't allow yourself to be pressured into signing a contract. Somebody gives it to you and tells you it has to be signed by the end of the day, and you've only had it for an hour or two. That is just a red flag. You don't want to be in business with those people. There's nothing that's that urgent. Typically, you need to have more time and to read and understand and potentially even negotiate agreements. So don't fall prey to high pressure tactics to get somebody to get you to sign an agreement. So that's what I have available for you today. I hope you have found it helpful. We have other resources available on our website, business health checks. These are um, uh, sort of questionnaires that help you think a little bit more about issues that are important to your business. We also have a weekly Legal Lowdown newsletter that we send out to business owners every Tuesday or Wednesday during the week. And these are one topic, quick read little emails. If you'd like to subscribe to that, we would love to have you subscribe to it. We also do this Lowdown webinar typically once a month. We're taking a break in August because I'll be on vacation, but we will do them every month thereafter, and it's always on a different subject. There is a replay available of all of our lowdowns on our YouTube channel. If you just go to YouTube and search for Fiffik Law. And we do a lot of estate planning too, and we have a variety of events coming up here along the way. So with that, I'll see if I have any Q&A.